And you brought this white man here to come and persecute us, because you know that every white man will go after the blood of the EFF. That's what he's there for. I don't care whether my legal representative says he's got respect for him. I've got no respect for him. He's a DA lawyer. He's a well-known DA lawyer who's here
Honorable
looking for
Honorable
blood.
Malema, can you make
The one is that 2 days ago, less than 36 hours ago, the legal team for the six affected members, who are all present in the chamber today, launched an application for a postponement of these proceedings. And before I ask them to introduce themselves and to motivate the postponement, if with the permission of the chair, perhaps I should just outline in 30 seconds what today's proceedings are about. The charges, as chair, you have correctly pointed out, relate to the events that happened on the 9th of February 2023 during the State of the Nation address by the President of the Republic of South Africa. And perhaps in 10 seconds, I may put on the screen that which happened. Immediately thereafter, I will hand over to our learned colleagues to introduce themselves and to then indicate their stance. Chair, after the short video, I would propose that you make a ruling that the legal team for the affected members take 30 minutes to motivate why the matter should be postponed without interruption by the committee members. I would then have 30 minutes to rebut their application for a postponement, and they have 10 minutes in reply to deal with anything that I've raised in my rebuttal to their application for postponement. Thereafter, the committee members could address any questions or queries they may have to the respective legal teams. So may I ask that the short clip
On the point of order. Point of order.
What is the point of order, Honorable Malema?
Chair, it is not the responsibility of the initiator to want to tell us how we're going to run the proceedings here. You can't tell us who's going to speak for how many minutes and who's not going to interrupt that person and who's going to respond for how many minutes. You can't tell us that. It's got no role to tell us that. It's your responsibility as a chair after the consultation with the team. You see, it's a problem, this thing that you hire minorities when you're charging Africans here. You did that with public protector. Now you brought a white man here who's coming to tell us what to do. We're not going to accept
Malema,
that.
Can
it's
you
a responsibility of a committee to tell us how we're going to run
so that I
proceedings.
can make a ruling.
Make a ruling. Make a ruling. But this thing of bringing white people, when you are charging us, you bring white people to come and prosecute us. We're being prosecuted by a white man here, a white male.
Honorable Malema, can you stop there, because you have made your point and I've heard you. I will make a ruling as the chairperson. Initiator, can you stop there? I will proceed with the chairing of the meeting, and I have acknowledged your point of order is sustained. I will make a ruling as the chairperson. Now I'm proceeding. I now ask the legal team because he has introduced himself and his team, I'm now asking the legal team of the affected members to introduce themselves, and after the introduction, and make their application. I will give them 30 minutes, of course, to motivate I'm allowing that. But before that, the legal team of affected members confirm with me the presence of all the affected members in the August House. Over to you, my legal team of affected members.
Thank you, Madam Chair. My name is Tembeka Ngcukaitobi. I'm an advocate in Johannesburg. I am in this matter with Mr. Ramohale and Ms. Sekwe, S-O-E-K-O-E. We act on behalf of Mr. Malema, Mr. Shivambu, Mr. Ndlozi, Mr. Dlamini, Mr. Pambo, and Mr. Tambo. I presume that they are all present. Mr. Malema has already announced himself, and I've seen the name of Mr. Shivambu on the screen. And perhaps we should simply ask Mr. Ndlozi, Mr. Dlamini, Mr. Pambo, and Mr. Tambo to confirm their presence, because I've not personally seen them.
Can you do so, honorable members, as requested by Advocate Ngcukaitobi?
Thank you very much,
Just
Chair.
to confirm.
Pambo. Thank you very much, Chairperson. Guyani Pambo here. I'm present.
Thank you.
Chair, I'm present, Marshal Dlamini.
Thank you, Dlamini.
That leaves Tambo and Mr. Ndlozi.
Thank you.
Chairperson, I'm here, Ndlozi.
Thank you, Dr.
Thank you, thank you, Madam Chair. If I may then proceed, there are two applications that we've indicated we intend making. The first application is for the committee to appoint an independent chairperson who might either be a judge, a senior attorney, or a senior advocate to conduct the fact-finding inquiry, and the matter will then be remitted back to the committee for its final determination. That's the first application. The second application is for these proceedings to be postponed to either a date or dates in January or February. We will be indicating to our learned friends the week in January or February that would be suitable. Let me start with the first application, which is the appointment of an independent chairperson to conduct the fact-finding inquiry. Firstly, the committee is bound by the common law rule against bias. Now, we don't accuse the committee of bias, but what we say is that the common law rule against bias means that you as a committee cannot be a judge in your own cause, and that it is important that there should be no perception, reasonable perception, that you are biased against the EFF. Secondly, you are bound by the provisions of Section 12 of the Powers and Privileges Act. Those provisions require you to ensure that the proceedings are reasonable and procedurally fair. We say that the only way to ensure that there is reasonableness and procedural fairness is that you should appoint an independent chairperson to conduct the fact-finding inquiry. And thirdly, you are bound by the Constitution, and I need not say that, it's obvious. But the requirements in Section 1C of the Constitution require you to ensure that you act rationally. And we say that the only way to act rationally in these instances is to appoint an independent fact finder. So let me start then with the first of those three propositions, the rule against bias. Now, the rule against bias is part and parcel of the common law rule of audi alteram partem, which is generally referred to as the natural justice. What it contains are two elements. The first element is that you should give a hearing to an affected party. Obviously, you are giving us a hearing. We are not objecting to that. But the second one is that the person who hears the matter should not be biased and should not be reasonably perceived to be biased. The problem that you have as this committee is that you are majority, according to the calculations of my learned colleague, you are 61% ANC members. You are sitting in judgment of your political opponents, the EFF. You therefore hold enormous power over your political opponents. And the issue at stake is a political issue. You have obviously framed it, or the prosecutor has framed it, as a breach of the rules. But what is clear is that on the 9th of February 2023, there was a protest by the EFF against its political opponent, the President of the Republic of South Africa. Now, you may disagree with my framing of the issue, but that disagreement is of no moment, because what we argue is that the person who makes a judgment against the EFF must not only be independent, but must also be perceived to be independent. So we ask yourself, we ask you to ask yourself the question whether any reasonable member of the South African public will perceive a hearing in which the ANC stands in judgment against the EFF as an independent hearing, particularly at the fact-finding stage. Now, this is not the same issue as presenting a bill for voting in Parliament, where majoritarianism applies. And this is not the same issue as deciding whether or not the public protector should be impeached, where again majoritarianism applies. This is an issue whether or not political opponents of the ANC in Parliament should be judged by the ANC. And it has severe consequences, not merely among the people that I represent, it has severe consequences among the voters. The effect of the matter is that some people in this country, more than 1 million of them, have chosen the EFF to represent them in Parliament. And although when the EFF is here, they are members of Parliament, the Constitution itself recognizes that they are opposition members of Parliament. That is why there is a rule in Parliament that there is a leader of the opposition. It is a recognition that they don't lose their political identity when they become members of Parliament. So we say that if you continue constituting the committee in the current fashion, you will fall foul of the common law rule against bias, and your proceedings will be unlawful and unconstitutional. So that is why we do not ask that the matter should not sit. We've never made that request. But what we do, we ask that the matter should sit before a neutral, independent chairperson to determine whether or not the political opponents of the ANC are guilty of misconduct. The other consequence of this is that if you look at the penalties that may be imposed in terms of the Act, the most drastic penalty is a suspension for a period of 30 days. Now, what that means is that the EFF, particularly its leadership, and I act here for the top leadership of the EFF, you can remove them from Parliament for a period of 30 days. And if you were to remove them in Parliament on political grounds, and not necessarily on misconduct, because we say that there will always be a stain that you are biased against the EFF because they are your political opponents. But if you remove them for a period of 30 days, what that means is that during that period, any deliberation, and it may even be a State of the Nation address next year in February, or it may be a deliberation on an important bill. But during that period, a significant part of Parliament that has been voted into by the public would not be able to participate, which means that this is not about Mr. Malema, but it is about the 1 million or so people that have chosen the EFF to be their representative in Parliament. So, argument one, we say that you should remove the stain of perception of bias against yourselves as the members of the ANC. Now, that, of course, does not mean you individually are biased. What it means is that the law regards you on a just perception basis as reasonably biased against the EFF, merely on account of the fact that these are your political opponents. But even if you look at the nature of the charge, it simply strengthens the political bias. This is a charge ostensibly for threatening the president. But this is not just the president of the country, he is also the president of the ANC. You are also members of the ANC, and I accept that you are acting here as parliamentarians. But there is an uneasy feeling that you will protect your own president against the EFF. And that is why you have to remove that perception and appoint an independent person. That person may be a judge, they may be a senior counsel, they may be an attorney. But we cannot see the downside. We cannot see the harm. We cannot see anything that would be harmful to parliamentary autonomy and parliamentary rules if you were to appoint a judge to hear this matter. Section 12 of the Act does not prohibit you from doing so. It does not require you to sit as the disciplinary committee. It merely requires you to ensure that the proceedings are fair and the proceedings are reasonable and the proceedings are rational. And the way to achieve the object of the Act is to appoint a judge to conduct the fact-finding inquiry. So we say, as a matter of the common law, you are obliged to do so. And as a matter of the statute, there is nothing preventing you from appointing a judge to hear this disciplinary hearing. Secondly, are the provisions of the Act itself. I have already explained that those provisions of the Act requires you to ensure that the hearing is procedurally fair and the hearing is reasonable. It is unreasonable, it is procedurally unfair that you should subject the top leadership of the EFF to a disciplinary hearing that is presided over by its own enemy, political opponents. Particularly so because you, as members of parliament, are also witnesses to the incident. You are witnesses to the incident because this happened on the State of the Nation address. You've also made a decision to institute the charges. These charges were not independently instituted, they were instituted by yourselves. You've also made a decision to choose the initiator. And obviously, you've tried to choose the initiator on the grounds that he is independent, which we appreciate. Mr. Katz is an independent man and is a colleague at the bar, and we have a lot of respect for him. That is fine. But what we ask for is that in the same way as you have appointed an independent prosecutor who is truly independent and who is not political, you should also find it in yourselves to appoint an independent judge so that we can debate whether the EFF is guilty or not. There is no benefit to Mr. Katz to sit here and prove a case in front of the same people that are witnesses, same people that have decided to charge the EFF, and same people that will be making the deliberations. So in sum, on this point, you are the judge, prosecutor, and sheriff in one. That is just wrong at so many levels. It's wrong as a matter of constitutional law, it's wrong as a matter of the common law, and it's wrong as a matter of the statute. We have seen the rules that Mr. Katz is permitted to be appointed as a prosecutor, but we say that there is a reason you chose him. You chose him because of his unique characteristic as an independent man, and may I add, also an honorable man. We say you should do the same thing for the appointment of the chairperson. And there is then the third requirement, which is you are bound by Section 1C of the Constitution, and that section requires you to act rationally, and it requires you to act within the scope of your powers. We say the request we've made is within the scope of your powers, but it would also be consistent with the principle of rationality. And if you did not do so, you would be acting irrationally. And it does not mean that you will necessarily find the EFF guilty. You may well find them not guilty. But what you will never remove is the stain that political opponents of the ANC, if they don't please the ANC in parliament, will be subjected to a disciplinary hearing, which ultimately is deleterious to our constitutional order and limits the ability of MPs to be robust when they are inside the precincts of parliament. If the EFF is guilty, as seems to be the view, if Mr. Malema is guilty, let a judge tell him that he is guilty. He will accept that. What is unacceptable is that he should be told by his political opponents who decided that he is guilty, who witnessed that he is guilty, who chose to charge him, and who have a political incentive behind his conviction and the imposition of a penalty against him. So let a judge, let a neutral person, let an advocate, let an attorney make this determination. It is a grave determination, and it should be made independently of yourselves. Now, that, of course, is not to cast an aspersion on you as members of parliament, but it is to state the reality that he cannot expect to have a fair hearing when he is subjected to punishment by his political opponents. So that's the first request. We ask you that you should appoint an independent person, and that person, we say, can be a judge or can be a senior counsel and can be an advocate, an attorney. If you did that, we will be back here in January or February. We will take 3 days or a week. We will finalize this matter, and you will hear no objections from us, at least on the process. And you will get the evidence you want to hear. And if you are confident of your case, you should not fear the subjection of this case before a judge. It is only when you are not confident of the case that you actually want to preserve it for determination by yourselves as politicians. The second application we want to make is a practical matter. This charge sheet was delivered on the 7th of November, and it schedules the matter for the 20th, 21st, and 22nd of November. The charge itself emanated from an incident on the 9th of February, 2023. So which means that for some reason, Parliament has delayed by 10 months. We have not been given any explanation why you have delayed for 10 months. If you thought this matter deserved to be dealt with speedily, expeditiously, and someone says even importantly, we have not been told why you have delayed for 10 months. So you've taken 10 months to constitute a charge on a single incident, one incident. So given that Parliament cannot explain why it has taken them 10 months to prosecute, there can be no urgency in having this application or this disciplinary hearing dealt with today or tomorrow. This is an application that can be dealt with in January or February. There's no reason why it should be dealt with this week. It can be dealt with in January or February. That's number one, is there has been an undue delay by Parliament in instituting these proceedings. And given the undue delay that has not been explained by Parliament, it is grossly unfair and unreasonable that we should now be railroaded, that the matter should be dealt with on such expeditious and speedy grounds. Now, I discussed this with Mr. Katz on Sunday. And then one of the points he made to me was that the rules say you are only entitled to 5 days. Now, that is true. But you must also, as Parliament, act expeditiously if you take these charges seriously. You can't wait for 10 months and then after 10 months, give us 5 days notice. That is just grossly unfair. You should give us enough time to consult, to study the video, to prepare, to raise any points we want to raise, to issue subpoenas, all of those procedural requirements. This is not a Stalingrad application. This is a sensible application to have this application dealt with properly in January or February. If you force us to carry on with a matter that we are not prepared, we are just going to sit here, listen to your evidence, and then thereafter ask for a postponement, because there is no way that we can run this case reasonably within such a short period of time. The second reason is that there is an application against Parliament that is in the High Court on the 4th of December. It has not been brought by this group of EFF MPs. It has been brought by a different group of EFF MPs. But it challenges the validity of the disciplinary proceedings against the EFF arising from a July 2022 incident. But these incidents are related because there is a commonality, which is the persistent view that has been taken by the majority party to prosecute the EFF for what it perceives to be infringements taking place inside Parliament. If that application is decided in favor of the EFF, then your committee will not be able to sit in any event. The current accused, let me say, charged or implicated members, Mr. Malema, Mr. Shivambu, Mr. Ndlozi, Mr. Dlamini, Mr. Pambo, and Mr. Tambo, have applied to join that application. And it will be heard on the 4th of December. So it's imminent. It is not as if it will take a long period of time. And one of the points that will be argued before the High Court is precisely this point of the incorrect composition of the committee. Now, the point may or may not be good, but it is irrelevant because the judge is going to make a determination on the 4th of December as to whether or not the committee currently as it sits is properly composed. So we ask you to remove the problem by appointing an independent person. But in any event, the matter is going to be decided by the judge on the 4th of December through interdict proceedings. And then the third point is that there has simply been insufficient time to prepare, and I've already made this point. Once you've taken 10 months to prosecute a case which you claim is a simple case, you cannot say to the accused, you only have a week to prepare. You have to take into account that you've given yourselves 10 months to prepare. Right? Parliament took 10 months to prepare this case. It cannot give the EFF 10 days to prepare. If the Parliament believes that 10 months is reasonable for it to prepare its case, it follows as a matter of logic that it must also give the EFF not 10 months. We ask only for 1 month. We will be back in January. We will be back in February. We can fix a date, fix a time. We're going to run the case. But the truth is that there has been insufficient time to prepare. And the sufficiency of the time can be judged by the fact that you yourselves took 10 months to prepare this case. There is a problem again about the discovery of evidence. That's number 4. One of the charges you make is this idea that there was a threat or intimidation of the president by the EFF. We're going to deal with this in evidence. But we've asked for a subpoena to be issued against the speaker. We will also ask for a subpoena to ask the president whether or not he was threatened, because an allegation of threatening a person is a subjective allegation. It is similar to the provisions of the Intimidation Act of 1982, which has Section 2 of which has recently been declared unconstitutional. But it is a subjective charge. In other words, I cannot say that X has been intimidated or threatened if X says I was never threatened. We know that you don't intend to call the president and you don't intend to call the speaker. But we want to issue the subpoena against the speaker or the president so that they can explain how they have construed the rules, and the president can explain whether or not he was threatened, because you've elected to charge us for threatening the president or storming the stage in a threatening manner. But the stain of the threat is to be felt primarily by the person who is alleged to have been threatened. It is a subjective charge. So whether or not the initiators will be calling the speaker or the president, we will be asking the committee to issue a subpoena against the president, or asking the speaker to issue the subpoena. Now, this is one of the reasons why this must be dealt with independently, because we don't want to place the committee in a position where it must make radical decisions about subpoenaing its own political leaders to appear in a disciplinary hearing. Whereas if this was an independent judge, it would be easy for an independent judge to say, I think witness X is irrelevant. I think witness Y is relevant, and therefore I'm declining your subpoena or I'm granting your subpoena. The problem here is that you have constituted yourselves as a political machine, And that we say is wrong when you are running a disciplinary hearing. So, but we say there is evidence we want to be discovered, including subpoena, but we also want the entire video. The video that we have been shown is very skewed. It shows a portion of the stage, and it is in circumstances where we have to interpret what were the EFF members that went to the stage trying to do. Were they trying to threaten the president, or did they have a different object? Could the president reasonably, on what can be perceived, be threatened? Or is the allegation of threat of the president simply made up in order to bolster an otherwise non-existent case? But those are matters that will be dealt with in due course. For now, what we say is we want a postponement so that we can finalize the question of discovery, so that we can finalize the question of who must be subpoenaed and who must not be subpoenaed. So we say that in those circumstances, it is just impossible. I mean, obviously, you can take the political decision to force the hearing. You've got the majority. There's nothing stopping you from doing that. But we say that if you took that view, it would be susceptible to judicial review. The most pragmatic thing is to postpone the hearing for a month, give us until January, or give us until February, and give us a week in January, give us a week in February. We reconvene, we call the witnesses. But in the meantime, it also gives you a chance to deliberate on this idea that we have proposed, that you are in fact under an obligation to ensure that there is independence and a perception of independence. My colleague, Mr. Ramokhale, has prepared written argument on the point I've made about the appointment of an independent panel. We will be submitting those shortly for the consideration by the committee. Thank you. I think I've probably not exceeded my time. I don't know, but thank you, Madam Chair.
Thank you, Advocate. You did not indeed, and I was still going to give you because I want to prove that issue of fairness and biasness. Your 30 minutes were still in, but thanks for the presentation. I will now request the initiator to do the same, to respond.
Thank you, Chair. I must start off by thanking my colleague for the kind comments he's made about me personally, and I share his sentiments that I'm an honourable person with himself. I've known him for a long time, and Mr. Ngcukaitobi has, in general, always acted in a manner that I would regard as honourable, wise, and intelligent. But having said that, he makes 2 points in his address to the committee, and I'd like to deal with them in the following manner. The first is I'd like to deal with this question of the composition of the committee and explain why, as a matter of law, the point goes nowhere. And thereafter, I will deal with the question of the application for a postponement. We have prepared written submissions on the question of the postponement, which I would like to hand both to the legal team representing the affected members and the committee. It'll immediately be emailed to the committee, and we have hard copies in the chamber to hand out to the legal team for the affected members. But turning to the first aspect, which is the question of the composition of this committee. The composition of the committee is set out in Rule 154 of the Rules of the National Assembly, which is part of Chapter 12. Chapter 12 deals with the committee system, and in clear and unambiguous terms, how this committee is to be composed, and the appointment procedures are set out in Rule 155. Now, unless and until those particular rules have been declared invalid for whatever reason, this committee is entitled to sit in the capacity it sits, which is to give effect to Section 12 and 13 of the Powers, Privileges and Immunities Act of 2004. And before this committee or before the High Court, there is no challenge to the rules in this respect. I know our learned friends suggest that there is, but we haven't seen it in the sense that there is this composition has been in place for many, many years. This committee has sat, and it would be interesting, and we would submit odd for the committee itself to find that it itself is unlawfully or improperly composed. And were there to be such a thought, the best way to deal with it is for the committee to get on with its business and make what is called a finding and recommendation, table it in the House, and thereafter let whoever deems it appropriate challenge the validity of the composition, not by way of just this particular composition, but by way of a challenge to the rule itself. That's how these things are done. So even if the committee is persuaded, which I submit it shouldn't be, that there's any merit in this composition point, it's not available for this committee at this point to take any action by, for example, appointing an independent person like the committee or like in respect of my appointment as the initiator. So the point doesn't get off the ground concerning the so-called unlawful composition of the committee. And this committee we would submit can ignore that point in its entirety. Turning to the question of a postponement, I have prepared written submissions, and let me start by saying our learned friend says that today's application for a postponement is, in his view, not Stalingrad. Well, we would disagree. We would submit that today's postponement on its face is Stalingrad on steroids. I will turn to why I say that in dealing with the application for the postponement as was filed on Saturday evening before this committee. There's no merit to the application, and the underlying basis of the application is unfortunately solely lacking in any substance. May I just check with my team whether the heads of argument have been emailed to the committee and given to our learned opponents? So, Chair, I trust that the committee members have now all received soft copies or by way of email of our written submissions. And I would take the committee to it because perhaps in listening to me, it'll be easier and quicker were the committee members to read my submissions as I proceed. In paragraph 1, we deal with the question of the notice to the 6 affected members. In paragraph 2, we deal with the content of those notices. And importantly, Chair and other committee members, what is interesting is that the notices were served on the 6 affected members on a Tuesday night. That following Friday night, or not Tuesday night, Tuesday afternoon, but that following Friday evening at 7:24, the attorneys for the affected members drafted a letter to the Speaker and the Chair, and on the Sunday, the Speaker, through the State Attorney, responded. But it's important to note that on the Friday evening's letter, which was written by Ms. Cupido of Ian Levitt Attorneys on behalf of the 6 affected members, certain points were raised concerning why a postponement should be granted, including the question of the High Court litigation, including the fact that there were, for example, 640 pages contained in the bundle, the hearing bundle. And on the Sunday letter in response, all of these points were taken care of so that, for example, it was explained in paragraph 20 of the State Attorney's letter to Ms. in response to Ms. Cupido, that it's all very well saying there's 640 pages in the bundle, but almost all the pages are formal documents such as legislation, the rules of the National Assembly, joint rules, and there was nothing, open quote, new that the 6 affected members would need any time to consider. So the insufficient time on the basis of the bundle is a non-starter. And one sees in paragraph 4 of my submissions that Ms. Cupido's letter requested certain information. There was a request, rather it was framed as a way of a demand that the hearing be postponed to a date in 2024. Again, after judgment by the Western Cape High Court in a matter to be heard on Monday, the 4th of December, 2023. The committee has heard from our learned friend the similar refrain today, and that refrain is included in the application for the postponement that was filed on Saturday evening. And what Ms. Cupido did in her letter was to threaten a High Court interdict to stop these proceedings, prohibit these proceedings commencing. And the response from the State Attorney was, that is inappropriate. It's inappropriate to approach the High Court, rather approach this committee, which is what they did. But the important point that I want to stress is that the 6 affected members knew as long ago as Friday, the 10th of November, that they wanted a postponement. That's 3 days after having been served the notices. And yet they waited 9 days to bring their formal application, the substantive application for postponement, without any proper explanation. And it's a factor that this committee will take into account in deciding whether to grant the postponement. They knew early on, so they would argue, that they didn't have sufficient time, but they waited 36 hours before the hearing, they bring their substantive application. And the courts have replete with authorities which say, if you know you're going to bring a postponement, if it's a good faith application for postponement, do it as soon as you know you want postponement. As soon as you're going to make your application for postponement, make it. But if you wait till the last moment, you're almost hijacking the decision maker to say, well, it's too late. We have to now listen to what they say at the last minute. So we take it further, and if I may turn to paragraph 11, it says there is now a substantive application in which a postponement is sought. And we submit that in paragraph 11, that this postponement application is an abuse. It's a clear stratagem of the 6 affected members to avoid taking responsibility for the alleged disruptive conduct at Sonar. They wish to evade the hearing and the charges at all costs. They were ducking and diving, and such conduct should not be tolerated. And I may just turn away from the note to make this point. Our learned friend has suggested, and we disagree with the suggestion, that the test for the charge of approaching the president and the speaker in a threatening manner is to be determined on a subjective basis. We disagree with him. It doesn't matter what the president, what the speaker, what the 6 affected members thought. It's what the objective facts show happened at the event. So if the 6 affected members had absolutely benign or peaceful intentions into jumping onto the stage in the middle of Sonar, the fact that what was going on through their minds is not an inquiry that this committee will consider. Similarly, what the president thought or what the speaker thought is not of relevance. If the president thought, well, I'm not threatened because I have the VIP protection, I'm not really threatened by 6 people jumping onto the stage while I'm sitting here. Or if the speaker thought similarly, she was at the back end of the stage and she couldn't be threatened because she was quite far from the action. It's irrelevant. So we would submit that it's an objective inquiry, and this committee will draw inferences from the conduct which the 6 affected members were involved in. So the conduct involving the 6 affected members is where this committee will go from an objective perspective. What are the inferences that can be drawn from jumping onto the stage at the time and in the manner that they did so? It's a simple issue. I then turn to the issue of Stalingrad, paragraph 13 of our note. This conduct of delay is classic Stalingrad. The 6 affected members have taken every step, reasonable and unreasonable, just to ensure that the hearing does not commence. On the version testified to by Ms. Cupido on behalf of the 6 members, a postponement is certainly not warranted. So what the committee will do is read and analyze and consider the application by the 6 affected members as testified to by Ms. Cupido. 4 corners of the application are Ms. Cupido's evidence and my learned friends addressed this morning, and make a decision on that. Simply put, we say in paragraph 15, the 6 affected members on their version have not made out a proper case to be granted a postponement. And so we conclude by saying at this part of the heads, there should be no postponement. We turn to give the committee some assistance by how the courts have dealt with applications for postponement. And we start off by in paragraph 14, it's 18, following the 14 to 17 paragraph. But in paragraph 18, we say in court proceedings, a postponement of a hearing is an indulgence. Let me repeat, it's an indulgence. And in 19, that indulgence will only be granted where the party seeking a postponement demonstrates that it is in the interest of justice to do so. That is the burden of a party seeking a postponement. Now, we accept that this committee is not sitting as a court, tribunal, or arbitration forum. It nevertheless has the power to consider an application for a postponement of a hearing. Let me just stop and say, it is suggested that this committee would find the 6 members guilty or not. That's not true. What the committee does is table a report in the House, and that report will include findings and recommendations. The Act, the Powers Act makes it, and the rules make it clear that the House itself is not bound to follow that report. So this committee plays a recommendatory role rather than a role of making a finding one way or the other. That being so, we make the point that when it comes to the question of a postponement and the court's guidance as to how the committee must consider and exercise its discretion, the criteria, the factors that the courts have set out play what we call an R40 or RI role in how the committee would decide. In other words, to the extent that a court has a discretion, the discretion is far more narrowly tailored and far more narrowly exercised when it comes to the committee itself. So the committee itself will decide, do we grant this party an indulgence? The committee will consider Ms. Cupido's affidavit with our learned friends' oral address this morning and decide with reference to the factors that the courts have set out, but those factors must be given heightened awareness in deciding whether to grant a postponement or not. That point is made in paragraph 22. In paragraph 23, we submit that a proper case must be made out. So there would have to be an explanation. Now, we've heard from our learned friend that the members, they may wish to call the president, call the speaker to hear what's in their mind. That case is not made out anywhere. It's not in the letters addressed by Ms. Cupido. It's not in the affidavit addressed by Ms. Cupido to this court. So one has to look at what is the application that serves before this committee. And the application doesn't talk to any of those types of considerations of who it wishes to call, who the 6 members wish to call, and why. So one would look at the postponement itself. And we say, as far as being given an opportunity to bring a constitutional challenge is concerned, in paragraph 24, the courts have now put their face against the notion that where there is a hearing, whether it be a criminal trial, a labor dismissal hearing, disciplinary hearing of any type, that a party facing the hearing should be entitled first to approach the courts with a constitutional challenge, and thereafter, if they fail, let the hearing go ahead. Courts have said that's not the way to do it. The general way to do it, have your hearing, and if you are not successful in opposing whatever's happening, if you're found guilty, or if you lose the labor case, or if you lose this disciplinary, then at that later stage, you may appeal the ruling, review the ruling, and bring your constitutional challenge. Not upset the whole apple cart by bringing your challenge and then staying in the proceedings for a year, for 2 years, for however long, while this constitutional challenge is traveling through the courts. And the Supreme Court of Appeal and the Constitutional Court have said over and over that way of doing things, of staying the proceedings, obtaining postponement after postponement after postponement, is inappropriate. Get on with your hearing, and if you're not successful, then you can bring your challenge. And that's classically the case like this. So, for example, let's assume the 6 affected members have their hearing, and it turns out that the report is one that the report that's tabled in the House is one that they feel comfortable with. They wouldn't bring the constitutional challenge because they would have been vindicated before this very committee. As it is said, perhaps the committee will find that they didn't jump onto the stage in a threatening manner. They didn't disrupt the proceedings as set out in Section 12. Well, then there's no need for the constitutional challenge to be brought. There's no need for all of the, let's call it, interesting constitutional aspects, the composition of the committee to be considered. And they would have been, open quote, not have any black mark or stamp against them. And the 1 million or so voters who have asked those representatives to be part of the House, they would have had their needs properly considered. So we say in paragraph 26, in this case, the committee may, after hearing evidence and considering argument, table the report in Parliament recommending that no action of any kind be taken against these members. And the members may feel that the inquiry conducted was reasonable and procedurally fair, so there would be no need to challenge its report in the House and the procedures adopted by the committee. Now, the point I want to make here is that to predict that the committee will act in an unreasonable and procedurally unfair manner is unfortunate and not warranted by the facts. This committee will act reasonably, will act in a procedurally fair manner, and it's not at this stage for the affected members to second guess how the committee will run its proceedings. We turn to paragraph 27. It's a point that I've already made. This application fits into the premature preemptive category repeatedly warned against by the courts. The postponement application is inter alia on the High Court in constitutional challenge, and then the arguments again are set out in paragraph 29 and 30. Ms. Cupido's arguments for postponement are premised on the potential unfairness and unreasonableness, not the actual unfairness or unreasonableness. And we say if it's potential unfairness or unreasonableness, that in and of itself is no basis to grant a postponement. This committee would then be suggesting, well, they claim they need more time, they claim there's a constitutional challenge, they claim there's 740 million. We as the committee, we don't think we're going to act fairly and reasonably, so we postpone. Doesn't work that way. This committee will do what it is required to do and continue its proceedings until such time as it finalizes the proceedings. And at that point, if the affected members are dissatisfied that they didn't obtain natural justice, fairness, reasonableness from the committee, it is at that point in the future that they may take up these challenges. So in summary, we say in paragraph 32, the members seek a postponement to await the outcome of some High Court case which may have no relevance or any bearing to this hearing. It is emphasized in paragraph 33 that before the House may take any disciplinary action against a member, the committee must, and it's an obligation on this committee, inquire into the matter in accordance with a procedure that is reasonable and procedurally fair. And if it ultimately transpires that the High Court and possibly the Supreme Court of Appeal and Constitutional Court judgments have some bearing on the reasonableness of this hearing and its procedural fairness, the affected members will certainly not be without a remedy. They'd be entitled at that stage in the future to bring whatever challenge they would want to make, concerning the so-called irregularity of these proceedings. And just let me say to the committee that even were the High Court challenge to succeed, that's not the end of the matter as far as the hearing or the fairness and reasonableness of this hearing is concerned. Section 172 sub 1 sub B of the Constitution gives the court wide remedial powers to make any order that is just and equitable in the circumstances. And it may well be, and one can't predict, that were the High Court to come to the assistance of the EFF and the Menti and Marais applicants as far as the constitutionality of that which is being challenged, it may, and we would submit probably would, make a ruling that despite the infirmities of the legislation or the rules, the proceedings would not be regarded as unreasonable or unfair. That would be what we would submit would be a serious possibility as to just and equitable remedy that the court might grant. But it's at that stage in the future that the affected members would have the remedies or rights, whatever they may seek, to challenge these proceedings. But what they try to do effectively is to avoid even having the hearing commence. And when they do that, one has to look at the substance of the application that was brought. And I've made the point over and over, Ms. Cupido's affidavit are the four corners of the evidence that one will consider, that the committee will consider, and they just do not get off the starting point. In paragraph 38, I've made the point. So, Chair, in paragraph 39...
Chief, I'm calling a point of order.
What is your point of order, Honorable?
His 30 minutes is finished, Chairperson. His 30 minutes is done. He's been addressing here for over 30 minutes. He must be organized.
I think I've had 21 minutes, Chair, according to my clock, but I might be wrong. 21 minutes at this point.
He's not talking to you. There is procedure in Parliament. Keep quiet. He's talking to the chair. Why are you talking? Why are you talking when he's talking to the chair? It's not talking to you.
Malema,
that's the problem of white supremacy. That's the problem of white supremacy.
According
you think you can just disrupt us like that?
According to my watch, he's left with 6
Dlagude,
minutes.
you want to allow what? Dlagude, you want to allow what? You want to allow what? We're not Dlagude. You want to allow what?
Honorable Malema, please, can you be orderly, please? I'm chairing. Can you respect the chairperson? You may raise your point of order, I will recognize you, but I'm responding to Honorable Ndlozi's point of order that advocate is left with 6 minutes. Can we allow him to proceed, please?
Yes, Chair.
Proceed, initiate.
Thank you, Chair. In paragraph 39, I was suggesting that the comments of the Constitutional Court in a case called National Police Services Union and others versus the Ministry of Safety and Security and others from 2000 should dominate this court's consideration of the application for postponement. In paragraph 4, the Constitutional Court stated the postponement of a matter set down for hearing on a particular date cannot be claimed as of right. An applicant for postponement seeks an indulgence from the court. In this respect, the applicant for a postponement must show that there is good cause for the postponement. And I'll move on to Myburgh Transport in paragraph 40, 41, Gravenstone versus Neertling, and in numerous other cases to the same effect. In 43, there's the full bench of the Cape High Court where the application was for a postponement in circumstances where the minister in that case, the Minister of Home Affairs, had filed no papers whatsoever in a constitutional challenge to legislation. And the court put in a difficult position because here it was deciding whether legislation was unconstitutional without any papers from the government. And the court refused a postponement partly because the application for a postponement was brought at such a late stage. So the real question is the late application in this case, together without any merit and substance to the application, we say would suggest that there is no merit. In paragraph 48, I've dealt with the bundle And I've dealt with the difficulty that the 6 affected members have, is that they complained about the size of the bundle when it was explained in correspondence that the size of the bundle was of no moment, because the words are, the documents are all formal in nature, such as the Act and the rules. There's no prejudice of any kind to the 6 affected members with this weighty bundle. There was no response from Ms. Cupido. The insufficient time aspect, which is in paragraph 50, is a non-starter. My learned friend is quite correct. Item 1 of the schedule to the NA rule states that a notification must be delivered to the member at least 5 working days before the hearing. In the present case, the notice were delivered 8 working days before the hearing. I know that there's a debate whether it was 7 or 8 days, but that's not the point. The real point is it's more than enough time for what is regarded as a single incident. It's 6 members having been asked to leave the National Assembly for good or bad or indifferent reasons, jumping onto the stage in circumstances where the President of the Republic of South Africa and the Speaker of the National Assembly and other presiding officers were present in a particular manner. And there may be evidence to the effect of what objectively the inferences that this committee can draw. So we submit in conclusion, paragraphs 51, 52, and 53. The current application 52 for postponement has been brought for one purpose only: to delay the commencement of the inquiry on unsustainable grounds. It has not been brought in good faith. It has been brought at the 11th hour in what may legitimately be regarded as an ambush. The application for postponement must be dismissed. And we would conclude there, and I hope that I have complied with my 30 minutes. I think I'm on 29 minutes, Chair, but thank you.
Thank you, Initiator. Before I go back to the legal team of the affected member, I would like to check with honorable members whether you do have any clarity questions to the 2 presentations, both by the legal team of the affected member as well as the initiator. I'm allowing that space now for you, honorable members of the committee. Please assist me by observing hands, our officials, staff members, if there are any. If there is none, it's fine, we'll proceed. And delay, do we have hands?
The Deputy Chief Whip, Chairperson.
Deputy Chief Whip, you are recognized.
Thank you very much, Honorable Chairperson. Good morning to yourself, the initiator, the affected members, legal team, and everyone on the platform. Honorable Chairperson, I want to welcome the presentations made by both sides. But I think it is our responsibility as members of Parliament to clarify some of the issues, even though the initiator has already done so. But we really need to emphasize this. Honorable Chair, I won't waste your time, but just to indicate that this committee is not made up of ANC members. There are other parties, namely the ANC, DA, EFF, ATM, and IFP. And the rules of the National Assembly allow any member of Parliament to participate in any committee, even if they are not members of those committees. So they allow for that. So any member of Parliament is allowed to sit. And again, Parliament, like any other institutions that are there, have its own arrangements. We are not a court of law. We are members of Parliament. We have our own mechanisms. Our own mechanisms that we use. I think it is proper for us.
There is a point of order.
Oh, okay. My apologies, Chair. My apologies.
Yes, can you allow that point of order?
Honorable member.
it would be helpful if you would chair this meeting, because you said you're calling for questions, not some narrative we're being given here. We must not be patronized. We know what this committee is. Why is she giving us a story? You said questions, and you must also stop sleeping there because you called for questions. Please.
It is not night. I'm not sleeping. Let us respect each other, because if I bounce back, you won't like that. Your point of order is sustainable. I was also going to respond to that other members must come up with clarity-seeking question. But thanks, because you alerted me that. But I observed that because the committee will still go and deliberate on that, and you are in order. But don't put any vulgar words which won't allow me to do that to you. So let's respect each other right from day one. Thank you. Honorable Tlakote, honorable member is in order. You are trying to outline, clarify the rules, and the initiator has done so. According to me, as the chairperson, I was requesting clarity-seeking questions. If we don't have, let's leave it in that way, because we will still have time to go and deliberate in the committee. So with due respect, the honorable member is in order. What I don't like is to tell me that I must not sleep. I'm not your child. Thank you. Honorable Tlakote, can you stop there?
Thank you.
And then
Thank you very much.
we'll go back to our legal team of our affected members to respond on the response by the initiator. Thank you.
Thank you very much, Honorable Chair. Order taken. Thanks.
Thank you, Chairperson. Let me start. I have 10 minutes, if I'm correct, Madam Chair.
Thank you, Advocate. You are right. You have got 10, but because you managed your time in the first round, I may allow you to add few.
All right.
I want you to be free, because here we're in the hearing, we're listening to each other. That Alderman party pattern is being observed. Thank you, Advocate. You may proceed.
Thank you. Thank you, Chairperson. Let me start then with the first point I tried to make, and maybe I was not clear, and I take responsibility for not being clear. The point I make is that the committee is ANC dominated. According to our calculations, in its current composition, it is 61% ANC. 61%. Decisions have to be taken on 50+1, which means any resolution that has the political patronage of the ANC will be carried through. There's no one who can say anything about that. It's a fact that the ANC dominates this committee at 61%. It's even higher than the National Assembly composition of 57%. The question you have to ask yourself is whether any reasonable person acting reasonably will believe that EFF MPs, including its president and deputy president, that have been subjected to a disciplinary hearing for a political act will receive a fair hearing. That does not mean you yourselves are dishonest, but it means that you are perceived to be politically biased against the EFF, and it is your job to carry out the mandate of the ANC. That is what the judges have said. But where you are going to sit in judgment, that's the point. Where you are sitting in judgment of your political opponents, it is absolutely essential to remove the stigma of bias. Now, I said at the commencement of my address, Madam Chair, that the rule against bias applies. Mr. Katz has not responded to that. He must be taken to accept that the rule against bias applies. Number two, I said at the commencement of my address that you are bound by section 12, subsection 3, subsection A of the Powers and Privileges Act. What that section requires you is that you must inquire into the matter in accordance with a procedure that is reasonable and procedurally fair. So you have a duty to set up a procedure which would be reasonable and procedurally fair. In our view, the procedure that you must set up is the procedure where a judge, a retired judge, conducts an inquiry into the facts and finds out who did what. There is no provision here that you must substitute yourself as a fact finder. Your job is to conduct, in fact, your job is to inquire in accordance with the procedure. So item 1 is develop the procedure. Develop the procedure. And the first item on that procedure is make sure that there is an unbiased judge who's hearing the matter. He can recommend to, he can make findings of fact and recommend to you, and you can vote as you wish. But the fact-finding stage is the procedure that must be presided over by a judge. Now, Madam Chair, you've been here, we've all been here. Mr. Katz has never said that the procedure of appointing a judge will be unlawful. Why? Because he himself knows that a retired judge is a guarantee of independence and fairness. He himself knows that you cannot subject EFF MPs to a political machine of the ANC over a political act. Everybody knows this. You can ram through this, railroad it because you've got the numbers, but it will not substitute the cogency of the legal submission that you have to ensure that the procedure you adopt is reasonable and procedurally fair. Now, that does not mean as a fact you will be biased. It means you are perceived to be biased. And perception of bias is as good as actual bias. Number 3, Mr. Katz says, look at the rules. And then he cites Rule 154, 155. Those are irrelevant rules. You can close your eyes as far as those rules are concerned. The relevant rules are Rule 211, 212, 214. They talk about the composition of the committee. We have no objection to the composition of the committee. We've never said anything about the composition of the committee. Our only issue is who is going to conduct the fact-finding. Is it a judge or is it the political opponents of the EFF? Now, when you look, and Mr. Katz says, this committee is not going to make findings whether people are guilty or not. But that means he has not paid attention to Rule 214. Look at Rule 214. It says, 214(2)(b), the committee must table a report in the assembly on its findings, underline findings and recommendations in respect of any alleged contempt of parliament as alleged in section 13 of the Powers and Privilege Act. And then it says, C, if it is found that a member is guilty of contempt or misconduct, the committee must recommend an appropriate penalty from those contained in section 12(5) of the Powers and Privileges Act. So anybody who says that you have no power to make a guilty finding can only say so in ignorance of the rules. We say you should not be ignorant of your own rules. You must know your own rules that you must make the guilty finding. Our submission is the rules do not require you to sit as the disciplinary committee. They empower you to appoint an independent person to make the fact finding so that there is no perception that the ANC is persecuting its political opponents. In other words, it's abusing its majority in parliament. So the debate about the rules is an irrelevant debate, completely irrelevant, because we've never said we want the rules to be struck out. We've never said we want the committee to be differently constituted. What we have said is the rules give you the power to appoint an independent judge in the same way as you've appointed my learned friend who is an independent initiator. Once you have done that, you will take the report of the independent judge, and thereafter you will deliberate and you will vote, and whatever the outcome of that vote is. But what will not happen, you are not going to have Mr. Malema being the subject of interrogation over a so-called misconduct, which is purely political, by his political opponents. That is the argument. And so far, I'm afraid to say there has been no answer to that argument. The only thing that has been done is we have been given the rules. We know the rules, we've read the rules. We could not have come here without having read the rules. We came here because we've read the rules and we have said there is a way in which you can protect yourselves from acting unlawfully by appointing a judge. And nobody has said that the judge is not the correct person to look into whether Mr. Malema committed misconduct or not. And thereafter, you will vote. You still have your majority and you can still decide what you want to do. And that it is wrong to say that there will be no guilty finding. The rules expressly use the word guilty of misconduct. Now, that's item number one. This idea that we are going to act fairly. We are going to act fairly. If a judge is biased or is perceived to be biased, he or she is removed before the case. The judge is not allowed to run the case. And after having run the case, to say, oh, look at me, I've given you such a fantastic hearing. That is contrary to every rule that exists in the common law, in the Constitution, and elsewhere. The judge is removed at the beginning. We don't ask you to be removed. We ask for something less than that. We say, conduct the fact-finding before a judge, take the report, and we will go there, we will defend ourselves. So that's very, very important to understand what the point that is being argued is. In fact, it goes back, I think it was Honorable Hlakude. I heard from that question that maybe it was my fault that I didn't clarify what I was saying, and that is why she's going on a wrong track in assuming that I'm attacking the rules. Instead of saying, I'm asking you to enforce the rules, because the rules require you to act fairly, reasonably, and rationally. And I'm asking you that in order to act fairly, reasonably, and rationally, appoint a judge. And so far, no one has ever said why a judge should not be appointed. There can only be one motivation where a judge is not appointed. It's because certain people want to settle political scores. That can be the only explanation why a judge should not be appointed. We have so far had no explanation whatsoever. So we insist on our initial submission that we ask you with the greatest of respect, get a judge, and Mr. Malema will subject himself to an independent judge. And that does not diminish your standing. That does not diminish the autonomy of Parliament. It retains it and it reinforces it. In fact, it even makes it more legitimate that you are prepared to say, let's get a judge, let's get advice, and then let's take it forward. By the way, this is not a radical thing that I'm suggesting. When you are disciplining yourselves, disciplining the public protector, you know the first thing you do? The first thing you do, you get a judge. You had Justice Ngabinde, you had, I think it was Justice Mohoro in the two matters. Even
Advocate, sorry, your time is up, but I'm giving you 3 minutes to wrap up. Thank you.
Yes, all right. So that's on the first issue. Let me leave that. I wanted to make the two examples. Public protector, you've got a judge who makes the first determination and then it goes to Parliament. So that's nothing new. Then let me go in the 3 minutes that is left to the issue of postponement. My colleague says, we left it too late. You know, Madam Chair, I don't know if you have this bundle of the postponement application in front of you. If you have it, I will ask you to go to page 39 and 40. We wrote a letter to, not me, but my attorney wrote a letter to Parliament on the 10th of November. And they said, look, can we please get this thing postponed? The state attorney, now that is Mr. Katz's client, instructing attorney, wrote back at paragraph 7, they said, we point out that it would be premature and an abuse to approach a court without first approaching the Powers and Privileges Committee with whatever complaint your clients may have regarding the notices and charge sheets that were served. So they said they cannot give us an answer. We must come to this committee to request the committee. Now, Madam Chair, listen to this. When we come to the committee, they say we came to the committee too late. They themselves said they couldn't give us an answer. The state attorney said, I can't give you an answer, go to the committee. Today we are in front of the committee. What are we being told? We are being told we came too late. So there is a fundamental inconsistency that is being played by the state attorney side. Then the last point to be made goes into the issue of Stalingrad. I have never seen a case where an application is made for the first time and where there is a commitment to hear the case in a month. I've never seen that case being reduced into Stalingrad. It's the first time. And so you have to be careful not to be hoodwinked by fancy terms, Stalingrad. It applies to Mr. Zuma's case, the judges have found. It doesn't apply to Mr. Malema's case. And Stalingrad applies in criminal cases and it doesn't apply in parliamentary proceedings. This is the first application, and we have said we are going to be back in January. We need about a month to prepare. And then somebody jumps Stalingrad. You have to be taken seriously in your job as parliamentary MPs. So in summary, we say, appoint a judge, we will appear. Number two, we say, give us time. We need about a month to consider this. The submissions have been circulated, I'm told, for the benefit of the committee. Thank you, Madam Chair. I hope I have stayed within the extra 3 minutes.
Carefully read and considered the application for a postponement of the hearing. The committee has also taken into account their legal representatives' argument in favor of the grant of a postponement. The committee has also considered the written and oral submissions advanced by the initiator. The essence of the complaint in the postponement application is that for the hearing to commence on the 20th of November 2023 will be unfair to the affected members. The committee has an obligation to conduct itself constitutionally and to act reasonable and in a procedural fair manner at all times. That is a requirement contained in Inter Section 12, subsection 3B of the Powers, Privilege and Immunities of Parliament and the Provincial Legislatures Act 4 of 1994. This provision requires the committee to inquire into alleged conduct of contempt of Parliament in a manner that is reasonable and procedural fair. A person who applies for a postponement seeks for an indulgence. He must make out a case for the postponement. If the affected members are dissatisfied with the manner in which the inquiry is conducted by the committee, they may take whatever steps they deem appropriate after the committee has tabled its report and findings to the House, and after the House has made its ruling. Taking all relevant factors into account, the committee has not been persuaded that the inquiry will not be conducted in a reasonable and procedural fair manner. The affected members have not made out a case for a postponement of their hearing. In the circumstances, the committee has decided that there is no factual or legal basis for the hearing to be postponed, and the inquiry should commence. No application for a postponement is refused. That's the decision of the committee and the ruling by the chairperson. I thank you. I will now call upon the initiator to put the charges to the affected members.
Chair.
Yes, Honorable Ndozi.
It's Honorable Malema.
Oh, Honorable Malema, sorry. Over to you.
Thank you very
Honorable.
much. We heard your response, and we don't agree with it because we believe that in every situation like the one we're faced with now, there will never be a refusal to grant a first request of postponement. It's very clear that we're being subjected to a kangaroo court, and which we're not going to accept. And you brought this white man here to come and persecute us because you know that every white man will go after the blood of the EFF. That's what he's there for. I don't care whether my legal representative says he's got respect for him. I've got no respect for him. He's a DA lawyer. He's a well-known DA lawyer who's here
Honorable
looking
Malema,
for our
Honorable
blood.
Malema, can you make your point?
And we're not going
Rabaka,
to accept that. I'm making a
I'm
point. You can't tell me how to speak. I'm making a point.
I'm requesting you not to be personal.
I'm
Respond
personal.
to the.
You can't tell me what to say. You can't tell me what to say. Let me make my point, and then you can rule me out if you want. So all I'm saying is you brought an apartheid apologist and beneficiary to come and persecute me. No white man can persecute me. I'm not going to allow that. And no white man will persecute the EFF. And we're not going to accept to appear before this white man and before this kangaroo court. You can go and be together in your own arrangement there. We are not going to participate in this kangaroo court because its outcome has been determined even before by yourself and the DA. That's why you brought a DA lawyer here to come and speak to us. He's not a man of integrity. He has got no integrity to can persecute us and will never be persecuted by a white man. We refuse to appear before a white man. We refuse to appear before a kangaroo court. Do what you want to do. Some of you won't come back to this parliament, especially you, Chairperson, and many of you. You are going to watch parliament from home. Whatever decision you take will still be in that parliament, whether that white man you called likes it or not, we will be in parliament. As a result, we recuse our legal representatives. They must now leave that place, and we're also leaving this nonsense of a kangaroo court. Thank you.
Thank you, Honorable Malema. That's your view. Myself as the chairperson, I don't care whether I come back or not, but I'm chairing this session. I'm proceeding with the hearing. My ruling has been, the decision of the committee is that we refuse the postponement and we are proceeding. I will now call upon the initiator to proceed as requested, to put the charges to the affected members.
And my learned friend has asked me for an opportunity to address the committee, and I have no objection to my learned friend doing so.
Thank you. I know, Madam Chair, that you're quite keen for the charges to be placed. I'm sure that will happen in a moment. I just want to note two aspects on the legal side. Mr. Malema has addressed the politics of the matter. The first one is we would like the transcript of the deliberations. Someone told me that they had listened to the deliberations. I think they were available on YouTube. There is a disjuncture between the deliberations and the ruling that has been given. So we would like to scrutinize that quite carefully. So we would like the raw data of what was discussed, because it doesn't seem to tie up with what has been delivered. That's number one. And then number two, we just note that we also asked for a ruling on the appointment of a judge. There has been neither deliberation nor decision on that issue, but both of those matters, we would like to take them up in the Western Cape High Court. But at this point in time, we would simply like the actual transcript of the deliberation. You have also heard that my client has excused me from the hearing, but I have to give due deference to the committee to indicate that in the absence of a client, I have no mandate to remain. My juniors also have no mandate, and my attorneys have no mandate. So if I pack my bags, it's because my client has instructed me to excuse myself. But I still need to get the final word from yourself that I can pack my bags.
Advocate Ngcukaitobi, you are leading the affected members. I don't think that I've got powers to can instruct you to do that. It's your right with your affected members to take a decision. The ruling made by the chairperson is the deliberation and the decision of the committee. I'm not a committee member alone, so I won't evenly say that go or do not go. My surprise is that you are leading them and you are representing them, but the decision have been done by the affected members rather than yourself. So I don't have any obligation to can say you stay or you do not stay. The ruling of the committee still stands. We are proceeding. Thank you.
Yes, Madam Chair, I understand that, but the point is that I don't want tomorrow that there is an issue that I acted in contempt of the Parliament or the committee. So that's the only point I'm making there, to say, look, you've heard my instructions, and but if you say you are neutral on the subject, then there's no problem.
I'm now addressing the hearing. As I've indicated that the ruling has been made and still stands, I'm proceeding. I'm now requesting the initiator to put the charges to the affected members.
Thank you, Chair.